Hi, I'm Arlo Gilbert, co-founder and CEO at Osano, and your host on the Privacy Insider podcast. Today, we have a special guest, Keith Enright, Chief Privacy Officer at Google. This is the first of a two-part series, so make sure you tune in when we release the next episode. Welcome to the Privacy Insider podcast. I'm Arlo Gilbert, CEO and co-founder at Osano. Today, we are going to be talking about big technology and what it's like to build privacy programs at one of the biggest companies in the world. We've got Keith Enright, the Chief Privacy Officer at Google. But before that, I do want to jump in and let everybody know, if you listened to the last podcast, then you probably heard me make a bet that we were going to have a federal privacy regulation within the next 12 to 18 months. I am by nature, as an entrepreneur, an optimist, but I think it was actually while we were even recording that last podcast that the Chevron ruling came down and suddenly everything had changed. We also saw that they had tabled the conversations around the bill. So bad news, folks. It's not looking likely that we're going to have a privacy law in 25. Maybe 26, 27. We'll get lucky. That's my current bet. But welcome to this episode. So we have with us today Keith Enright. Keith, welcome to the show.
Thanks for having me. It's a pleasure.
So Keith, you are at the helm of what would probably be called one of the most complex and challenging privacy programs in the world by virtue of being at Google. So Keith, you're the Chief Privacy Officer at Google. We would love to know a little bit about what it's like in the hot seat and maybe tell us a little bit about how you got into privacy in the first place.
Yeah, sure thing. I mean, I imagine we will spend a lot of time for the rest of the conversation talking about what it's like organizing, building, and operating a large, complicated privacy program. I'm a little bit reticent about sort of going deep on my origin story. I'm happy to do that if people are interested. I've done that before on podcasts, so I don't want to repeat myself too much. I will say back about 25 years ago, I was a law student. I was working at a labor and employment law firm, not focused on privacy at all. But I was sitting in a law library one day and I was thinking about the intersection of declining costs of storage, digital storage, with Moore's law and the fact that computers were getting more and more powerful every day. And as a pure kind of moment of intellectual curiosity, I was thinking, that intersection of those two forces, which were being widely reported on at the time, computers were getting vastly more powerful. It was getting very, very cheap to store data. I was wondering what that meant for the future of privacy. It seemed like there were going to be tremendous commercial incentives to collect far more data than we had ever collected before. Our capacity to do so is going to increase. And our ability to do things with that data at scale, to create economic value, to create utility for people, was going to get pretty remarkable based on the trends that we were seeing. And I wondered, I didn't see a lot of people thinking about or writing about how the intersection of those two forces, the relationship of those two forces, was going to affect the way we thought about privacy. And people's ability to control information about themselves.
Well, it sounds like your magic ball, your magic 8-ball was right. Compute costs and storage costs went down and the internet exploded. When you think about your early days of getting into privacy, I mean, what was the world like at that point in time? And I don't mean to date you here. I think we're about the same age, but your law school days were really around kind of when the internet was fairly new, right?
Sure. Yeah, this was really the era of the first ad tech bubble, I would say. We're talking about 1997, 1998. And it was really interesting. After I had set up my website, it had only been a couple of weeks later, I got a call from a reporter who was coincidentally located in South Africa, who was writing a story for about.com about a proposed merger. There was a company named DoubleClick, which is now part of Google, but at that time was not. And DoubleClick had announced that they were acquiring a company called Abacus Direct. DoubleClick was an online ad tech company. Abacus Direct was a more traditional catalog data company, offline data. And DoubleClick was positioning this merger as allowing them to synthesize these online offline insights to do a better job than had ever been done before of showing the right ad to the right user at the right time, to make advertising both more useful to the people who were seeing it and more effective to the advertisers and publishers who were trying to monetize. Commercially, that was all very interesting, but there was a privacy advocacy organization that complained to the Federal Trade Commission saying that that proposed merger was going to be in violation of restrictions that were in place based on the privacy policies that govern the company. So that created a story. It was a largely unsettled area of law. Not many people had looked at these questions before. And when reporters began looking around for someone to opine on it, they found me because I was a kid with a website that nobody seemed to know what it was a kid because of the way the internet operates. So I was a presumptive expert. So I was called in to have a bunch of conversations with media, first with this about.com article, and then that sort of blew up, and I ended up in conversations with reporters all over the world who wanted someone to talk about how the law of privacy was developing. Now, for me, that created a really interesting opportunity. I first was perceived as being an expert externally, even though candidly, I was still just educating myself and learning about both the state of the law and the underlying technologies. But because I suddenly had a voice in the space, I was invited into other conversations. There was a group of people trying to pull together a professional association for privacy professionals at the time. And these were truly some of the titans in the field. Folks like Alan Weston, who was one of the original authors of the Privacy Act, Bob Belair, who was one of the leading lawyers at the time, Ron Plesser, who was one of the leading lawyers at the time. They invited me to participate in putting together this professional association. So I was rubbing elbows with people who were incredibly accomplished, really smart, really thoughtful, and have been serving clients in the space for a long time. Now, when we look back with the benefit of hindsight 25 years later, it's interesting. You look at the IAPP, which is the largest professional association by orders of magnitude serving the privacy profession. The IAPP actually absorbed that much smaller privacy organization that we had tried to put together in those early days of the profession's infancy.
That was a really great story. When you think about young law students today and their futures in potentially compliance and privacy and technology, how do you think that things have changed, not from a technology perspective, but more from a career perspective for people who are trying to get into privacy? And then the other piece of that question is, when you look back at it, do you feel like your long form writing was ultimately the catalyst that really unlocked those relationships?
That's a super interesting question. So I would say there's two ways to look at this question. I try to set aside a good deal of time to talk to students and people that are early in their profession to kind of sort through some of this stuff. What do they want to be as their career develops, and what's the best way to position themselves for longer term fulfillment and success? There's two things. It's important to understand I didn't set out to be a privacy lawyer or a privacy expert. I was on track to be an employment lawyer who just happened to set up a website about privacy, and then destiny kind of pulled me in that direction because an opportunity presented itself, and one thing led to another. At the same time, I was doing a bunch of other things. So I was not really a traditional law student. I went to GW in DC, had a great experience there. But from the beginning, I just wasn't sure that a traditional legal career was resonating with me. I wasn't sure that was the direction I was going to want to go in. I knew that technology was where I wanted to be. I had been working on the internet, and we can talk about that later if anybody wants to, like for years already. So I was obsessed with technology. I was incredibly optimistic about its capacity to make people's lives better. And I knew that I wanted to be a part of that, but I hadn't figured out how to stitch together my love of technology with my law degree and my legal training and sort of the legal profession that I had set myself on a path for. So what I was doing at the time when I was a law student, I was looking for every opportunity to insert myself into a conversation about the practice of law as it relates to cutting edge technology. At the time, for me, one huge area of opportunity, the American Bar Association had a science and technology forum and had a bunch of working groups that operated under that. These were not typically populated by law students. These were practitioners that were publishing and doing that kind of work. but I just showed up for these things. I signed up for everything that I could. I was fortunate to be in Washington, D.C., so I was physically proximate to a lot of the meetings that were happening. And I would weigh in on things like digital signatures, public key infrastructure, some of these really interesting technologies that were already understood to have potentially profound consequences on the practice of law and on commercial behavior. And I would just show up with humility and offer to do anything. I would edit, I would proof, I would help people prepare things for web publication. I would just do all kinds of things. I think that model, hustle, look for the thing that you like, try to understand where you think the puck is going to go and skate there, and just relentlessly socially network so that you're connecting with people who appear to be thinking interesting things and doing interesting work. Those kinds of behaviors will pay dividends no matter what area of practice you end up in. None of those are privacy specific. I was extraordinarily fortunate that those behaviors brought me into the context of privacy and connected me with a lot of really interesting and capable people. And that germinated into what turned out to be an incredibly rewarding and exciting career. I still think there's a ton of opportunity in privacy, but it's not exactly the same play that I ran, right? Between then and now, we now have privacy as one of probably the most well-developed areas of commitment and focus for large law firms. Lots of firms have privacy and adjacent practice groups. They have partners that have been doing this for decades. They have teams of capable associates that are now very experienced providing this kind of advice and counsel to different kinds of clients. That wasn't the world that I stepped into. And the same play that I ran when I was in law school, when I graduated from law school, it wouldn't work the same way now, because now I would be out there competing with hundreds or thousands of other very capable lawyers graduating from top law schools competing for those same opportunities. I didn't have that. For me, I was carrying a lot more risk, being hyper specialized in an area where it wasn't certain there was going to be a career. And because my bet paid off, it created a tailwind that carried me very far, very quickly. I still think the opportunity that I seized exists today, but it's probably not privacy specific, right? I think if you're thinking about AI, for example, you can't get into a conversation about tech law without it veering into a discussion of how is artificial intelligence going to disrupt legal practice? How is it going to change the way we're doing our jobs? I think there is a tremendous amount of opportunity for young, ambitious, technically sophisticated lawyers to think about specific businesses that they're interested in, or specific problems or things that are fascinating to them. And then think about how artificial intelligence and machine learning are going to disrupt those areas, and then figure out how to help solve those problems. How do you engage with those particular areas in a way that's going to be uniquely valuable because you're passionate about it, you know something, you have the time and you have the intelligence to help other people navigate the tripwires that are forming because you're studying the law, you're studying the technology. I think that's one area. I think you've seen the same sort of thing manifest around Web3, around blockchain. Like, the technology continues changing, and it creates these opportunities for folks to become hyper specialized and become really, really capable legal advisors to help businesses and to help others navigate what is otherwise a very uncertain and confusing future. Like, this is what I find most interesting now. When I'm talking to people about career advice and coaching and advancement, I try to help them just think through that to find the opportunity like that that really works well for them.
That is amazing feedback for anybody who's looking to get into a career in law or regulation or technology. When you think about your career, and I know we've got a lot of topics we'd love to talk about today, so I'll try and be really quick in my conversation. How did you end up getting engaged with Google? I mean, did Sergey show up at your house and knock on your door with some flowers? What was the process like to become a Googler?
There are so many long, funny stories around that. It's hard to pick exactly the best way to tee it up without burning through all of our time. The honest answer is I was working at Macy's in Bloomingdales. We were headquartered in Cincinnati, Ohio. I'm born and raised in Boston, so I was a transplant into Ohio at the time. And I received a phone call from Google that suggested they were going to be bringing in someone to build and lead their privacy program. And would I be interested in interviewing for that position? I was so skeptical at that moment that I genuinely thought maybe they were trolling me, because I just didn't think that as much as I was enjoying my role at Macy's, and I thought that I would be content there for the remainder of my career, I really didn't think that a company as incredible as Google would reach out to me proactively and invite me to apply for a role. But I did, and that was in October of 2010, which did not culminate in an offer until March of 2011, which tells you something about Google's application process at that time. And the rest was history. So yeah, I moved out to San Francisco, and I was told on my first day that we were just about to sign a consent decree with the Federal Trade Commission, which had been being negotiated for months prior to my joining, and that my first responsibility was going to be help the company prepare for the new requirements that we were going to face under that consent agreement. The primary one being which we needed to build a comprehensive privacy program covering the entire company, our entire portfolio of products and services. And we needed to have it independently assessed by a large, sophisticated third-party entity every other year for 20 years. So it was about building a program that effectively managed privacy risk in a way that sort of didn't overly handicap the business, but as difficult, especially at that time, given how quickly the company was growing, do it in a way that you would be able to demonstrate that accountability, that you'd be able to demonstrate with a high level of confidence to someone outside of the company that you were doing the right thing, that you were behaving responsibly, and that the various kinds of policies and controls you had in place were operating effectively all the time.
That's an amazing origin story. And I feel like we've talked a lot about how you got into privacy, and we've talked a lot about your journey now. And I know our audience would love to learn a little bit about what it's like being in the hot seat. I know that as a technology professional, I have my list of kind of 5 or 10 people who I think would be fascinating to sit down and talk to, right? They're the rock stars of my world. And I imagine that for the privacy professionals in the audience here, you're a little bit of that rock star, and the Google is kind of the big stage, if you will. And so I think what would be really interesting, our audience runs the gamut from folks who are chief trust officers at some of the largest organizations in the world, all the way down to lots of young people who are trying to figure out what does privacy mean, how can I get into it, and then a lot of business people who are trying to understand how privacy might impact their own business. And so when you think about it through that lens, I'm really curious, how do you feel like your experience at Google and running and operationalizing privacy at Google is significantly different than, at a smaller business, or perhaps at a business that has a little bit less of a public posture in front of the regulators?
Sure. I mean, in many ways, it's night and day, right? Candidly, I have the benefit of perspective because of the different kinds of organizations that I've worked with. I did 3 startups straight out of law school. Then I was with a large global consulting practice where I saw a diversity of clients, public and private sector. Then I worked with large, 100-year-old businesses that operated large offline enterprises. One of them owned a bank, before I ultimately ended up at Google, which was this sort of explosively growing technology platform all around the world. There are a few immediate features that I would say distinguish Google and a very, very, very short list of companies from just about anywhere else. And some of these things change over time, right? For most of my tenure at Google, one feature that differentiated us from everybody else has been our leadership understood it, right? Again, part of my story was my role at Google was in part the result of the fact that we had made some mistakes as a company. We tried to launch a product called Google Buzz, didn't work quite the way we expected it to. That resulted in some legal challenges. The company resolved those with a consent agreement, and that consent agreement said we needed to create this comprehensive privacy program and subject it to external scrutiny. One benefit of that, never waste a crisis, was my CEO and the board of directors of the organization knew before I ever set foot on campus that privacy was an imperative for the company. And if they wanted flexibility to execute their long-term product strategy, they needed to make sure that they addressed this. They didn't want to be in constant friction with sort of large policymakers and regulators around the world if they were not making appropriate investments and they weren't thinking about being a responsible actor in the space. That benefited me tremendously. And candidly, that was a shift in sentiment. I was very fortunate that I always worked for great companies. I never had a role where I felt like my work wasn't appreciated, I wasn't appreciated, and privacy wasn't a priority. But if you look at something like a 150-year-old retail organization, they are not going to have the same sense of risk associated with it that a company like Google is going to. If you look at a company that has not ever had a major legal challenge in the context of privacy and data protection, you're not going to feel the same kind of urgency as you will in an organization that's being very strictly scrutinized every hour of every day for everything that they do. So I had the benefit of executive visibility, buy-in, and support from the get-go. And that never really faltered. Different challenges face the business. You look at Google today, AI is a massive imperative for the business. One of the things that Google needs to get right for this next chapter is going to be, how do we position ourselves as the most trusted company on earth, as a company that is trying to deliver useful and valuable products and services to its consumer and commercial clients? But how do we do that in a way? How do we maintain velocity without hitting these privacy tripwires, without getting something wrong? And it's very, very challenging when you're trying to move fast and you're doing it in an area where the law is unclear or the law is changing. And virtually every regulator and every policymaker around the world is watching you, not only to be confident that you're doing the right thing, but also if you fumble, if you make a mistake, it's a very efficient way to send a signal to the entire ecosystem to initiate some sort of an enforcement action or an inquiry against you. One of the challenges of being very, very large and being a leader in industry, even being widely recognized as having one of the best programs in existence in the world, is that every policymaker around the world is actively watching to see you stumble, because calling you out is a really efficient way to send a signal across the entire economy. This is what we don't want you to do. We want you to do some other thing. That's always been a challenge of sort of representing companies that are this large and are operating at this scale globally.
So when you think about your time at Google, I think about some of the challenges that our audience deals with, right? And there are always going to be questions around budget and resourcing. And we know that privacy often has to pull in budget from security and from legal. I'm curious, as much as you're allowed to share, how have you thought about that at Google, and how have they structured that at Google? Do you have to kind of go on a project by project basis? Is this no, we have a big bucket of money allocated to compliance from which you to pull? I'm curious just how y'all have structured that.
Sure. So, for every company I've ever been with, and in many ways, Google isn't any different, compliance and risk management and the relationship between compliance and risk management and your broader general business strategy, it is never and should never be static, right? Every quarter, every year, you are thinking about the risks you are taking, the risks you are carrying, and you're looking at your business strategy, and you have your compliance leads, you have your product leads, you have your legal leads, and they're having an active dialogue saying, are we in the right place, right? And what adjustments need to be made? That's working as intended. It's also the case that the law is unsettled in many areas, right? So many times you find yourself as a lawyer having a conversation with your internal stakeholders to say, we believe we are on the right side of the law here. We recognize that there may be advocates, members of civil society, potentially private litigants, potentially regulators who will take different positions than the ones that we have staked out. We may face legal challenges in some of these areas. We may lose in some of these areas. It may even be the case that we have inconsistent outcomes in different parts of the world. And then we need to lean back and think, okay, our general approach to product strategy is we want to offer the same experience to every user of our products and services everywhere in the world. That can become increasingly challenging. So one of the interesting challenges of operating at this scale is figuring out where your bright lines are, what risks is the business not allowed to take? And there, it's some of your baseline things: keeping users safe, complying with the law, and wherever you stake out a legal position, have a credible, defensible position to support the position that you're taking. And then have a candid conversation with your leadership to say, these areas here, they might get challenged. And they may ultimately rule that we were wrong about a thing or two. And you need to be engineering your products and services for flexibility so that you can adapt to that new reality. Now, I think one of the challenges that every large multinational company is dealing with right now is the level of compliance complexity across disciplines, where historically privacy has long been a very significant area of new incremental regulation and legislation. New requirements have come in, but it's been accelerating. It's been significantly up and to the right year over year for the last decade. If you look at just the last, say, 5 years, these requirements are coming from all sorts of adjacent areas of the law as well. Competition law is getting significantly more complicated. Laws regarding the provision of services to children, consumer protection law is getting much more complicated. How do you deal with harmful content online? So there are so many areas of the law that are now accelerating and complexifying in the way that privacy and data protection law has for the last decade. I think every company is now trying to zoom out a little bit and think about, we don't want to deprioritize things that we know are important, like privacy and data protection, but how do we think about our compliance efforts so that we are efficiently deploying inevitably finite resources to manage all of these requirements as effectively and efficiently as possible? So it's not about being less good in any one area, but it's how do we take our compliance investments, the technology, the tooling, the people, the policies, so that when we're solving problems in the context of privacy and data protection, we're not missing an opportunity to also solve a potential competition problem or mitigate a risk of harmful content online. This is where I think the next level of program maturity that we're beginning to see. We're going to see organizations kind of reconfiguring themselves, experimenting with new titles and new roles as we figure out how do we deal with these next generation problems, which are significantly more complicated and complex than the already very challenging problems that we've been grappling with for the last couple of decades.
Got it. So I do have one other question as a Googler. Can you code?
No, I do not even cosplay being a highly technical person anymore. I would say very early in my career, I was very into web design. So I had modest abilities to do things that were then moderately impressive to some people, but this was decades ago. And the rate of change and my level of responsibility for the last many years has precluded me devoting a whole lot of time to keeping my technical skills intact. And fortunately, again, at Google, I have the benefit of being surrounded by extraordinarily talented and capable people that I can lean on whenever I need sort of technical insights or expertise.
That is fantastic to hear, because I think most of the people listening on here also can't code. And so it is good to know that you can lead a privacy organization in a highly technical organization without necessarily needing to be that deep technologist. Be sure to catch part 2, where we will deep dive into what it's like to be in the privacy hot seat at one of the most recognized companies in the world.